Hey everyone, Harry here to talk about the administration's latest emergency appeal to the Supreme Court seeking an administrative stay of a ruling by a district court in California requiring them to reinstate all the 16,000 or so probationary employees that they fired. Okay, you may remember, it's hard to keep track of them all, but there were two opinions issued about the same time, one from Maryland and one here from Judge Alsip. This had some really pretty incendiary language calling out the illegality of the firings. These are probationary employees. They enjoy substantially less, fewer procedural rights than do vested employees, but they still have some. And the administration just completely steamrolled them and, to the district court chagrin, told them, I don't know why these guys lie so promiscuously, but basically said this is about performance when it wasn't. And that really got the district court stander up. So the district court issued an injunction ordering them to reinstate employees. The administration filed an appeal. And as part of its appeal to the Ninth Circuit, it moved there for an administrative stay, a kind of immediate, even more than stay of that you would put in a general sort of restraining order, but just like hold your horses, please, for a second. We are really suffering irreparable harm while this goes forward. The Ninth Circuit declined to do it, a 2-1 decision, with the Trump appointee on the panel being the one. And the argument basically there and in the Supreme Court has to do with standing, because this was a hastily filed lawsuit and it was organizations that came into the fray right away. And those, often engender standing battles about tell us how you as an organization are harmed by these employees being fired. And they gave two arguments. One had to do with some of them are the fired employees are members of unions or organizations, and that's us, and so we're being harmed. The court rejected that based on the law as it stands. But then others said, we are users of services that the federal government provides, and we are being harmed right now because we can't use the parks and federal facilities and the like. And that was the theory of standing that was recognized. Okay, so that goes up. And the 2-1 vote, the Ninth Circuit declines to enter an administrative stay. The appeal is still with the Ninth Circuit. But because it's been lodged with the Ninth Circuit under Supreme Court rules, as long as the appeal is down there, you can go to the Supreme Court and seek a so-called administrative stay. And they do that, and you've seen cases in which Justice Thomas, say, is the person who gets it in the first instance. That's because he's the circuit justice for, I think, the Fifth Circuit. This is Justice Kagan. So she has received it, and she'll decide. She's likely to refer it to the full court, or she can call for a response by the plaintiffs. It's a little complicated and contrived in that a second amended complaint has now been served that includes plaintiffs who were personally fired, and the standing claims have been much more shored up. So it's a little bit of a do-over nothing to the extent they're looking at standing. Now, that's not what the administration wants them to look at solely, because it's a pretty interesting brief. They are sort of taking their first shot at getting the court to disparage, and they can do more than disparage. They can, prevent or state a rule limiting the issuance of injunctions by district courts. Now, that there's two aspects to this kind of argument. One is it's problematic for district courts to be able to issue injunctions that apply to the entire country. And indeed, it is. We saw that when, say, Matt Kaczmarek in the Amarillo division of the district court in Texas, and they were able to steer things through him, entered an injunction about mifepristone and said you can't do this anywhere in the country. Of course, that wouldn't prevent a court from entering a injunction as to all the plaintiffs before it. And so if there's a valid class, say, involving these 16,000 employees, it surely would apply nationwide. But that's one of the things that they are saying. And then second, there's a whole kind of invective where they, let off steam, but definitely have some, Alito Thomas bait about mere district courts countermanding the executive branch of the United States, and this is they've been scumming up the works of government, etc. Now, there's another name for that state of affairs. It's called the rule of law. You pass a proclamation, an executive order, you violate the Constitution, and a lawsuit is going to be brought. And a lawsuit, you can't bring a lawsuit in the Court of Appeals. You bring it in the first instance in a district court, and that's the way it works. So this grousing is maybe a kind of good populist talking point. Why should a single unelected federal judge? You see J.D. Vance talking that kind of stuff, day in, day out. And now Trump has picked up the refrain. But it's really essentially lawless or a frontal attack on the whole legal system. The whole point is, if they're standing, courts are the one-person lobby. If you've been injured, you go to courts and you can make the entire government stand down. Chief Justice Roberts talked about the kind of majesty of that state of affairs in his confirmation hearings. That's how it works, and that's how it's designed to work. And the notion that somehow a district court shouldn't be able to enjoin the government is arrogant in the extreme. And whether they've thought it through or not, I could see it either way. Really a derogation. I just would fully undermine the rule of law in the country, which of course is part of the overall agenda here. So we'll see whether that makes it a little bit more attractive, if that's a little catnip for, I'd say, Justice Alito and Gorsuch and Thomas. But this is an administrative stay, so it's the whole emergency situation, about oy vey, you've got to stop this because we're suffering every day. Now, of course, it's all which way you look at it and whose ox is gored. The plaintiffs, or not the plaintiffs, the employees are suffering every day because their job is out. You can see the point that the plaintiffs whose standing was accepted, who are not able to enjoy, say, federal parks, they're suffering every day, but it might seem less exigent. But in the Court of Appeals, there was kind of an argument about what is the status quo that needs to be, frozen to prevent injury. And the administration-centric point of view that the Trump appointee endorsed is it's having us be told any single day, you must hire these guys or you can't hire those guys. That is that status quo is what's injurious day in, day out. And the plaintiff position is known. The status quo that is injurious day in and day out is these guys don't have their jobs and they've been fired for unconstitutional reasons. So that's a little bit of a parlor game about, how to conceptualize the status quo. Might or might not play out in the Supreme Court. But what happens next is Kagan decides what to do, and they'll probably serve it up to the court. If they you could see it going. You could write possible opinions either way, But if they take the case, even on this emergency basis, it'll be really interesting to see whether they kind of flex their muscles in the administration's favor and the disfavor of plaintiffs by talking about this, supposed plague of district courts. And there have been dozens applying injunctions to administration actions. Of course, there's a reason for that, which is that the administration is acting so lawlessly, so rampantly. So that at the Supreme Court level, if it plays out, those kinds of disputes look kind of different and more abstract, and there's more this institutional deference to the coordinate branches, blah, blah, blah. In other words, you could imagine them all that's at stake now is, do they freeze the district court order and say you can rehire people or do what you want in administration while we continue to adjudicate, or do they keep the freeze in, as the Ninth Circuit did, and say, no, while we're doing this, you may not hire other folks, and you must rehire these probationary employees, even though you say it's such a terrible state of affairs for you. Of course, what'd you think when you fired 16,000 probationary employees? So, got to see how this plays out in the next couple of days in the Supreme Court. And there is, as I say, this broader theme that the Supreme Court might bite on, which would be a bad day, given the way the overall landscape here about trying to inhibit or assail district courts for granting injunctions against administrative action, against administration action, which, as I say, is exactly how the system is designed to work. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.